Buenos días, mi nombre es Alfonso Miranda y soy el director del CEDEC, el Centro de Estudios de Derecho de la Competencia, con sede en la Universidad Javeriana. Hoy es 20 de marzo y estamos aquí reunidos con la increíble visita de Scott Hammond, quien dirigió la aplicación criminal del Departamento de Justicia por varios años, y Scott ha trabajado en el Departamento de Justicia por más de 20 años en la aplicación del derecho de la competencia, principalmente en los temas de aplicación criminal de la ley antitrust y los programas de clemencia. Good morning, Scott, and thank you for being with us this morning.
Good morning. Buenos días.
Scott, we are going to use, as we discussed, a format of questions and answers for our audience of the CEDEC, and what we want to ask you in the first place is Colombia has had competition laws since 1959, and as many Latin American countries, we have had administrative application of the competition laws. I think that we have a very strong authority. Since the 1991 Constitution, we have had a very interesting application of the competition laws, and only in 2012, with the anti-corruption statute, one conduct in Colombian competition law has become criminal, which is the bid rigging in public contracts or administrative contracts. And we think that this is very important because one of the important problems of in our country is about corruption. We are very worried about corruption and the embezzlement of public funds, and so we think that the competition laws can be an excellent instrument to fight this problem that doesn't allow the country to develop well. So we have a lot of curiosity because in reality the superintendency has had only the first cases, and we don't really know how the competition laws will work together with the criminal laws and the criminal enforcers. So what we want to ask you first is how is the application of the criminal law in U.S. antitrust law? And how does the competition enforcement work together with the criminal enforcement? And about, of course, your experience in this area, your extensive experience in this area in the United States.
Okay. Thank you. And good morning to everybody who made it here so early this morning. Well, let me first start by saying that in the U.S. we have an advantage that doesn't exist here and doesn't exist in nearly every jurisdiction, which is that the competition authority and the prosecuting authority are a single authority. So the antitrust division of the U.S. Department of Justice is a competition authority, like the SIC, or like the DG Comp in the European Union, or the other competition authorities around the world. But it is part of the Department of Justice. That means it is also a federal prosecuting agency. So the antitrust division of the Department of Justice investigates violations of the U.S. antitrust laws, and if there is sufficient evidence to warrant a criminal prosecution, it will bring criminal prosecutions. Now those cases are then tried in front of a jury, so it's not both a prosecutor and a judge. There's a separate judiciary that will, and then these cases are brought in front of juries, and so a defendant has the right to be tried before a jury of his peers or her peers, and so there is a separation in that sense. But to get back to your question, we have a single competition authority that also prosecutes, so we don't have that division. Now I started by saying that makes us somewhat unique. So the situation here actually would be the norm, that is that you have a competition authority and then you have a separate prosecuting authority. Now that does create challenges. There are many jurisdictions though around the world that have overcome those challenges quite remarkably and quite successfully. The Canadians are a great example for the Colombians to look towards. You have the Canadian Bureau of Competition, and then you have the Canadian Ministry of Justice. And those two authorities work very, very close together. We call that hand in glove in terms of the type of cooperation and coordination that exists there. The prosecuting authority is a separate independent authority with its own independent prosecutorial discretion, but it still works very closely with the competition authority. There are other good examples of that. Actually, right here in Latin America, Brazil would be an excellent example of a jurisdiction where you have the competition authority, which is CAGE, that works very closely with the federal prosecutor's office. Now, coming back to your question about criminal enforcement, it's also not unusual what exists currently in Colombia, and that is you have both an administrative sanction for competition offenses, and then separately now you have, for a single category of anti-competitive activity, bid rigging, there is a criminal sanction. So that is, I can think of other jurisdictions, for example, Germany is an example, where, and France I think is another example, where competition offenses are treated as administrative sanctions, but they single out bid rigging for criminal prosecution. In the United States, we would prosecute criminally all horizontal restraints on competition. We would refer to that as hardcore cartel offenses, hardcore cartel activity. And so that would include not only bid rigging, but also price fixing, horizontal agreements between competitors to fix prices, or to allocate markets or customers. All of those offenses are treated as criminal sanctions and are prosecuted criminally.
When you refer to hardcore, we like this expression very much, but in reality it refers to the gravity of the conduct, and only horizontal conduct will be hardcore?
Yes, that's right. Yeah, it refers to conduct that is unambiguously anti-competitive. And under our laws are considered per se violations of the law and are subject to criminal prosecution.
But it doesn't refer that the market is small or the consumers affected are few.
No, it does not. No, you could have anti-competitive conduct like a merger that is considered to be anti-competitive because it will result in dominant behavior. You could have unilateral conduct that can be anti-competitive and victimize consumers or potentially other competitors. And that can have a great impact on the economy, but that conduct is not considered criminal because sometimes it involves conduct that is very difficult to find where the line is between what is anti-competitive and what is not anti-competitive. But in this category of conduct of horizontal cartel activity, we've tried to draw a very bright line in the United States. There's a bright line in the law, and there's a bright line in the way the law is, and the Justice Department exercises its prosecutorial discretion just to target that conduct that is unambiguously anti-competitive and harmful.
So, when you are at the DOJ, how does the DOJ decide to go criminal into a case, or what are the thresholds that have to be met for the DOJ to be interested in bringing a criminal investigation?
Well, again, it has to be as I described, as hardcore cartel activity.
Horizontal.
It's got to be, yes. So we're looking at bid rigging, price fixing, and customer or market allocation agreements. Then, because the resources of the Department of Justice, like any other government authority, are limited, so there would be some review in terms of the allegations, whether there's sufficient evidence to warrant an investigation, and also whether or not the allegations are sufficient in terms of the potential harm caused by the conduct to warrant the allocation of resources.
And how long will a criminal investigation last? How long does it take to conduct a criminal investigation?
Well, of course, as you would expect, that varies. based on the size of the investigation, and by that I mean not just the amount of commerce involved, but the number of companies involved, individuals that are being investigated, and how quickly the investigation advances. But the average investigation probably lasts about 2 years. But that would be 2 years from the start of the investigation until the prosecution of at least the first 1 or 2 companies.
Mm-hmm. And there is this decision, the sentence is taken by a federal judge, right?
Mm-hmm.
And it will be appealed?
Well, actually, the vast majority of the cases that the Antitrust Division brings are a result of guilty pleas.
Mm-hmm.
And so in situations where individuals or companies accept responsibility and plead guilty and enter into plea agreements, then there's not an appeal of the sanction.
Uh-huh.
So I would say, no, the vast majority of the convictions in the United States, not just for antitrust but for other crimes, are not appealed.
So you were telling me that if the standard for the criminal case is not met, the DOJ will not be involved. The DOJ never goes into civil application of the antitrust law?
Well, so in this area of hardcore cartel activity, if the Department of Justice opens up an investigation, say of suspected bid rigging conduct, before we could bring a criminal prosecution, we would have to be satisfied that we could prove that case beyond a reasonable doubt, which is the highest criminal standard, highest burden of proof in the United States, to a jury. And if we don't believe that we can meet that standard, and I can assure you it's a very, very high standard, appropriately so, then the Department of Justice will close the investigation. What the department would not do is determine that there is hardcore cartel activity that they believe took place, but they don't believe that they can satisfy the criminal standard of proof. They would then, what would not happen then is to decide to bring that as a civil case, taking advantage of the lower standard of proof in order to bring a case. Now you might ask why that is, because that does mean in certain situations, just because the Department of Justice can't meet that very high standard, that it will close an investigation without taking any action at all. And perhaps that would mean that conduct that could have gone punished, at least with respect to a civil sanction, goes unpunished. There are a couple of reasons for that. The first is that it's very important to have very bright lines. We are talking about criminal sanctions where people can lose their liberty, and therefore it's very important for there to be very bright lines so that when those lines are crossed, criminal prosecutions are appropriate. And if there was a situation where the Department of Justice was bringing both criminal sanctions or seeking bringing civil cases for the very same conduct, but the only difference is the measure of proof that was developed with respect to that conduct, then there is a great possibility that the message with respect to this conduct is criminal would be lost. It would be blurring the lines in terms of what is criminal conduct and what is not criminal conduct. And I'm not comparing antitrust offenses to murder, but you don't have cases in which just because you can't bring a criminal standard of proof that you prosecute other crimes under civil sanctions. So if the determination is made that the conduct is criminal, then it should be either prosecuted criminally or it shouldn't be prosecuted at all. Now there is a little bit of a safety net that does exist in the United States, and that is that it's not just the U.S. Department of Justice that can bring causes of action involving horizontal or even hardcore cartel activity. The victims of the conduct can bring their own causes of action in court, and they can seek damages. And so,
but in that case, the case becomes civil.
And that's a civil case in which the victims are seeking what can be amount to triple damages for the conduct involved.
Mm-hmm.
So there's that opportunity so that the conduct doesn't necessarily go completely unpunished.
Yes. Tell us a little bit about the punishments. What kind of sanctions are applied when we are talking about a criminal antitrust case?
The punishment is very severe, and that's why I said it's very important that also that there be transparency in terms of what conduct is subject to criminal prosecution, and then what conduct the Department of Justice will investigate criminally, and what cases it will bring criminally. The maximum jail sentence for individuals is 10 years. The average jail sentence imposed in antitrust division cases over the last 5 years has been approximately 2 years. So that's a very, very stiff sanctions being imposed. On top of that, individuals are subject to fines in addition to jail sentences of up to $350,000. Corporations are subject to fines under the Sherman Act of a statutory maximum of $100 million. But there are routinely, the Department of Justice is able to obtain fines even above $100 million by relying on what's called the alternative fine statute, and that is based on looking at the gain or loss associated with cartel activity, and so in some cases, fines have been imposed of up to $500 million.
So tell me if this is accurate. In a big criminal antitrust case, it can happen that the natural persons are imposed jail sentence up to 10 years. Then the company has a criminal punishment as a fine of $100 million. And then the victims, the consumers, could sue for hundreds of millions of dollars or whatever in damages. That can be the outcome of an antitrust case in the U.S.
Yes, you've just described a typical major international or domestic antitrust case in the United States.
Do you think, with your experience, do you think that the criminal application of antitrust law should be the standard for every jurisdiction?
No, I don't think it should be the standard for every jurisdiction, because I don't think because there are many jurisdictions that are not ready for that standard. Mm-hmm. So I wouldn't say that I think every jurisdiction should immediately move to criminal sanctions, criminal investigative tools, and have criminal prosecutors handling all of the cartel investigations. But what I can say is that I do believe that criminal sanctions offer the single greatest deterrent to cartel activity. That if you accept the premise that cartel offenses are very harmful to consumers, and very harmful to the economy, that if you accept the premise that cartel activity is fraud, and it is theft from consumers, and it should be treated no differently than other crimes involving theft or other financial crimes, then they warrant criminal sanctions. It has, if you have criminal sanctions, you can certainly do a better job protecting your economy. I think a good example, and having said that, I'll recognize that U.S. Department of Justice model is the minority if we're talking about the rest of the world. Now, it's a situation where it's an increasing minority because many jurisdictions are transitioning to criminal sanctions, but it still is the minority. I will tell you that during my time at the Department of Justice, when we began to prosecute criminally international cartels that were targeting consumers around the world. In the late 90s, in the vitamins investigation, when we, for the first time, began to incarcerate foreign executives from outside the United States, the deterrent value of that was enormous. And one of the things that we began to see were international cartels that operated around the world but actually stopped at the U.S. borders. And that was because the individuals involved were concerned about going to jail. I mean, let's face it, these crimes are committed by very sophisticated individuals who have a lot to lose. And in many situations, it's a calculated risk. And if they're making a dollars and cents decision or a calculated risk, and they believe that the worst thing that can happen is that the company may be fined, then they might believe that it's actually a good business decision to collude with their competitors. But when you introduce into the equation the possibility that those same individuals may have to go to jail, and they may lose their liberty, it changes the calculation. And it can change the calculation quite dramatically, to the point that you are able to actually deter the conduct from taking place at all. So I certainly do believe that antitrust offenses of the kind that we've been talking about are no different than other financial crimes, and frankly can cause far greater harm than many other traditional criminal offenses. But I recognize that transitioning to criminal sanctions is a very difficult thing to do, and it's something that takes time.
Very good. Scott, also in our antitrust laws, we have a new institution since 2009. The new competition law brings for the first time the leniency program into the Colombian antitrust. This is a very new institution for us in antitrust. However, of course, Colombia has some experience with cooperation with the authority and reduction of sanctions in criminal matters, since the government of President Gaviria for the fight against the drug cartels. There were some laws enacted at that time in order to grant some kind of immunity to people who would, accuse the co-participants in illegal conduct. So now we have it in antitrust. We have a leniency program. However, there is not yet one decision in Colombian antitrust in which the SIC concludes the case and shows what was the participation of a leniency applicant and how it applied the benefits that can be absolute immunity or reduction of fines. And there are some characteristics in our law. Basically, we have one article in the law, and then we have a decree that develops this article. But what it says is that a person who is involved in anti-competitive conduct and comes forward to the authority and accuses himself and all the other companies or all the other participants in the anti-competitive conduct can obtain full immunity if he is not the instigator or the coordinator of the cartel, and that the first person will obtain can obtain the full immunity if the cooperation is effective and it brings the evidence to the authority of the anti-competitive conduct and accuses all the participants and gives all the details. So basically, that's what the leniency program asks for, an effective cooperation with the authority. We are still going to learn how it's going to work for Colombia. I think that for the business community, it would be still strange to go and accuse themselves and accuse everybody else. But why don't you explain us what is the importance of the leniency program and what should be what is the experience in the United States since when you think it's successful, and what should be the pillars of an effective leniency program?
Okay. Well, the United States Department of Justice actually had a leniency program that dated back to 1978. Actually existed from then until 1993, and it was hardly ever used. It was the only one of its kind, but it was well intentioned, but it was unsuccessful. And the reason why it was unsuccessful is because it lacked predictability and transparency, and so there wasn't confidence in the antitrust bar and the business community in its application. In 1993, the program was revised to make it far more transparent and predictable for companies that self-reported before an investigation began. It was actually referred to as automatic leniency. In addition, it was we covered individuals and the protection under the program. So a company that came in and self-reported could also receive protection for all their officers, directors, and employees of the company would also receive protection if they cooperated and came forward along with the company. That change in 1993 has completely transformed the U.S. Department of Justice's cartel enforcement program, but it also has transformed cartel enforcement around the world. Because after the division began to have success with that program, other jurisdictions began to adopt similar programs. First it was in Canada, then it was the European Union, and a few more countries here and there. Now we're at the point where virtually every significant competition authority around the world has a leniency program modeled either closely or loosely after the U.S. Department of Justice's program. And I think there's probably, I don't know at last count, nearly 100 leniency programs around the world. Not all of them are working, however. Alfonso talked about the pillars of a program, and it's a good place and a good term to use. That I sometimes just refer to them as the cornerstones of an effective leniency program. And there are really three. First, you have to have an effective leniency program. I'm not just talking about drafting a program and a piece of paper. I'm talking about a program that the bar and the business community will utilize because they have confidence in the fairness of its application, and because they believe that it is the best choice between several bad options if the conduct is detected. First pillar is that you have to have stiff sanctions. That is, there has to be a reason, a fear of those sanctions in order to self-report. Clearly, criminal sanctions creates a greater incentive to self-report than civil sanctions. Can you have an effective leniency program if you don't have criminal sanctions? Yes, you can. The European Union is a great example of a jurisdiction that doesn't have criminal sanctions but has a very effective leniency program. They also impose really, really, really heavy fines.
Yes.
So you have to bear that in mind as well. But there has to be, the sanctions have to be severe enough that it will cause a company to want to self-report. The second cornerstone, though, there has to be a risk of detection. It's not enough just to have really serious sanctions if nobody believes that the competition authority on its own would ever be able to detect the conduct, much less ever prove the conduct, because it lacks the investigative tools or the ability to successfully bring investigations to a successful conclusion on its own. Without that real fear of detection, you don't have the second cornerstone. So you have to have heavy sanctions, and then you have to have an authority that can create, it can bring cases on its own and have create a fear of detection. The third cornerstone, and this is where the Department of Justice fell down between 1978 and 1993, is you have to have transparency and predictability in its application. So even if you have the first two cornerstones, you can have the most heavy sanctions on the planet, and you can be the most effective enforcer in the world. If you don't have a leniency program that provides transparency and predictability with respect to its application, then nobody's going to come in and self-report the conduct. That doesn't come easy. And frankly, it's very difficult when you have criminal prosecutors involved, because criminal prosecutors really value their prosecutorial discretion. And it's very difficult. You can't have a full exercise of prosecutorial discretion and have transparency in your program. Instead, what you have to do is create a program in which its application is virtually automatic. And what you have to imagine is being in this boardroom, this hypothetical boardroom, where a company discovers that it's been involved in cartel activity. Now it's trying to make a decision what to do. Imagine yourself standing in front of the board. You're the lawyer for the company, and you're saying, well, the authority, in this case, let's say the SIC, they have a leniency program. So one option is to self-report. In many cases, the company's going to say, well, do they have an investigation? No, we don't think they have an investigation. Well, why are you telling us to come in and tell the competition authority about the conduct? Well, at that point, they're better. If that practitioner does not have as an answer, if we come in, this is what is going to happen, and be able to provide with assurance, we will be eligible for a full pass from prosecution, and these are the requirements or conditions for leniency, and we can confidently predict that we will meet those conditions, and we can confidently predict that we will be treated fairly, and that the application of the program will be in good faith. You have to have all of that. If you don't have all of that, there's no way you will get to the point where the company will make the decision to come in and self-report. So the good faith application of the program, the transparent and predictable application of the program is critical. And in any jurisdiction, it's difficult to get there because sometimes you have to develop a track record. It wasn't the case in the United States that in 1993 we developed a program where we had a line out the door because we didn't have a track record yet. But gradually over time, the Department of Justice developed a track record, both of fair application of the program and the transparent predictability of the conditions. I can tell you, though, one jurisdiction did have a line out the door the first day that the program went into effect, and that's Japan, which is interesting. So Japan was an example of a jurisdiction that many people said, particularly Japanese practitioners, because I sat on panels in Japan where other people on the panel would say that a leniency program is fine in the United States, but it will never come to Japan. That there are cultural and institutional and legal obstacles. The Japanese companies would never self-report and implicate other Japanese companies in cartel activity. It's just culturally unacceptable. Will never happen here. Well, the JFTC is an exceptionally good competition authority, had an exceptionally good chairman at the time named Chairman Takashima, and he understood what it took to put together an effective leniency program. So before the leniency program went into place, he worked very hard to shore up these three cornerstones. That's an authority that has both, that can bring administrative sanctions, but there is a criminal antitrust law as well. He made very clear that they would be making criminal referrals in cases, and they did so in a very major case before the leniency program went into effect. He also ramped up sanctions for cartel activity, got the Diet in Japan to pass laws to raise the sanctions for cartel activity in Japan, got new investigative powers for the JFTC to increase their search warrant powers, came out with a very transparent program, made very clear that the criminal prosecutors in Japan also embraced the leniency program for the first company to self-report. And so when all of that was taken in place, then the program went into place, and they literally had a line out the door for leniency applications. And now our example of a jurisdiction that probably has as many leniency applications as the United States Department of Justice.
So you were also telling us that when the cases are criminal in the United States, usually there is also a leniency applicant? There is?
Well, we have leniency applicants in the vast majority of our cases. Certainly not all of them, and they don't all begin with leniency applicants, but the incentives are great to self-report. So if leniency is available, it's quite often a race, and one company usually will get in first. I haven't mentioned this, but this was also one of the changes in 1993, is that we created the leniency program to allow for leniency both before an investigation begins, as well as the possibility for leniency after an investigation begins, so long as the company is the first to report and the investigation has not progressed to the point that the division already has collected sufficient evidence so that you can bring a case even without the help of the leniency applicant. So there is both type A leniency, which is before an investigation begins, and type B, which is after investigation begins.
Good morning, Scott. Would that transparency component that you make reference to includes the disclosure of information that the applicants provide to the competition authority? Or?
No, not at all. So that's a good question. So I talked about the importance of transparency, and so the question is, are we also transparent then with respect to the information that has been provided publicly? And the answer to that is actually no, quite the opposite. The Antitrust Division has a very strict policy of confidentiality, so we treat as confidential the identity of the leniency applicant, as well as the information that's provided by the leniency applicant, and go to great lengths to protect that information. There is, the exception to that is, as I mentioned before, the vast majority of cases in the United States where there are prosecutions are resolved through plea agreements, but there are some cases that do go to trial, and in situations where there is litigation and the case is going to trial, then, as you would expect, the due process rights of the defendant require us to provide evidence to any accused, and then that would also include any benefits or agreements or promises that have been made to cooperating witnesses. And so if a cooperating witness has been promised immunity in return as an employee of a company that received corporate leniency, then that would be revealed, as well as the evidence that was obtained from that leniency applicant. But that information is still protected to the greatest extent possible.
Yes, some of the questions and worries that we have with the application of the leniency program here in Colombia are related to the constitutional rights of other companies, because the leniency applicant is going to come forward to the authority and bring all this evidence and ask it can ask the authority to maintain its identity secret, and all this evidence is maintained in a leniency file that is confidential, and probably the authority is going to start an investigation, and so we wonder how other companies who probably think that they are innocent, how are they going to be able to defend themselves if they don't have access to this evidence? How is the authority going to treat this problem? And so my question is for you is, how in the United States, how the other defendants that are not in the applying for the leniency are going to be granted their constitutional rights to defend?
Well, again, so if you have a company that's under investigation and it's not the leniency applicant, it of course has the right to defend itself. And if it believes that it has not committed a violation, or is not satisfied that the evidence is sufficient to sustain a conviction in court, then of course it always has the right to, if criminally charged, to plead not guilty and to take its case to trial, where it will have a right to a trial by jury. And in that situation, if it is criminally charged, it has there'll be rights of discovery, and so that will include, again, having access essentially to the government's file in the sense of any evidence that has been obtained. So any documents that have been obtained, including documents obtained from the leniency applicant, will have to be shared with the accused. Any witnesses that will be witnesses against the defendant Any statements that have been made by those witnesses will have to be shared with the accused. And any promises or assurances or inducements made to the witnesses to secure their cooperation and testimony will have to be shared with the accused. As I said, that represents the minority of amnesty applications and cases because, quite frankly, in most cases where there's a leniency applicant, it gives the Department of Justice an incredible amount of evidence from the beginning of the investigation. That quite often leads to another individual or companies cooperating with the investigation. And the
So like everybody confesses. Even if they will not get the full benefit, they will cooperate with the investigation at the end of the day.
Well, it's not the case that every single investigation results in guilty pleas by every single subject of the investigation, because some investigations, because sometimes the department, believe it or not, opens investigations in which there are no violations, and so it reaches that conclusion and it closes the investigations. But yes, in situations where there's a leniency applicant, they quite often result in cases in which all of the subjects of the investigation end up pleading guilty, accepting responsibility and pleading guilty. And yes, as that investigation moves, there are also very significant rewards for companies that are second in.
In the sense of reduction.
In sense of a reduction in sanctions, both for individuals and for companies. But the incentives, the rewards, the reductions, they diminish as the investigation goes on.
Depending on the position that the company has in the leniency line.
Well, we don't call second reductions for second or third leniency. You could call it lenient treatment, but yes, the reductions in sanctions, the credit for cooperation reduces because naturally the added value that is being provided reduces as you start talking about.
But everybody who comes forward will get some kind of lenient treatment.
Well,
even if they don't, already all the evidence is there, they cannot provide any new emails or any new documents or any new testimonies, but they want to cooperate. Will they receive something anyway?
Both the Department of Justice would recognize an acceptance of responsibility as justifying a reduction in sanction, and even if the Department of Justice didn't, most courts would as well.
Is the leniency program a program just for the company, or can it be natural person leniency? Are there cases in which the natural persons go against their own company or against the legal entities?
Yeah, that's a good question. So in the United States, there is an individual leniency program. So the answer to your question is yes. In reality, it doesn't get used nearly as often as corporate leniency policies. But an individual could come forward and self-report the conduct and receive a pass from prosecution. The conditions are somewhat similar, in terms of that you have to be the first individual to report. You cannot be the ringleader or organizer. You have to terminate your conduct, and you have to cooperate, of course, fully with the investigation. It doesn't, as I said, it doesn't get used very often, but that doesn't mean that it's not actually quite important to the entire process. It is because it polices the corporate leniency policy. Because again, now let's imagine we're back in this scenario in the boardroom where the company's trying to make a decision whether to self-report. And the company is weighing these factors. One of the factors it has to weigh, at least in the United States, is if the company doesn't self-report, what if one of its individuals does? Because the company may be trying to make this dollars and cents decision. Well, if we report the conduct, how high would the fine be? Is it worth it? We're going to face these other collateral damages. We haven't talked about private damage actions. There's going to be a lot of consequences. Even if we self-report, it's going to be a costly matter. But what about the individuals? I mean, the individuals, doing a different calculation. That calculation is, I could go to jail for this.
But obtain also fine? The
Yes.
natural person
Yes.
can be fined?
Sure. You find up to $350,000. No, excuse me, up to $1 million under the statute. And fines are significant, but I don't think that's at that point what they're thinking about. They're thinking about jail time. And so a company has to be concerned that if it doesn't self-report, that one of its individuals will. And so that certainly polices companies in their decisions whether to self-report. And it also, again, is a factor in terms of why criminal sanctions can make leniency programs so much more effective, because they do create the possibility of pitting the individuals against the company.
So it wouldn't be unnatural to have a natural person who is adversarial with the company, that has a totally different position in the case.
No. So the beauty of the leniency program, one of the reasons why it works so well, is because it's a situation where the company's interests and the individual's interests are aligned. And that is, there are a number of positive consequences that result from that. It obviously makes, first of all, I mean, the one I just mentioned a moment ago, it makes the leniency program so much more, makes it more generous, and it makes it more attractive, because everybody stands to benefit from it. It also is enormously helpful if you are trying to find out what happened. So if you're a company and you're actually, you find out that there's potential wrongdoing involved, and you actually want to get to the bottom of it. If the company has been involved in antitrust violations, that's against corporate policy, and the company wants to root out any cartel activity and any violations, so it's going to conduct an internal investigation. Well, I can assure you it's much easier to conduct an internal investigation if you are sitting down with the individuals and you're saying, look, the company is conducting an investigation. We are trying to determine whether or not there have been violations of the antitrust laws. If there have been violations of the antitrust laws, either hypothetically we can talk about a situation that the company has already obtained a marker for leniency and stands to obtain full immunity and cooperates fully, or even if it hasn't obtained leniency yet, we're looking, and if we find that there have been violations, we can report those violations, and it's not just the company that stands to benefit, but you stand to benefit. If you cooperate with the company's investigation, you can also receive a pass from prosecution along with the company. You can imagine that can be much more effective in terms of inducing the full cooperation and allowing the company to conduct more effective internal investigations. Because I can tell you that's not what happens in most other criminal investigations involving companies. In most other situations, when companies are conducting investigations, this is outside of the antitrust division leniency program, say in an FCPA case. The company's conducting an internal investigation, it's asking its employees to cooperate with this investigation. And I'm sure that the lawyers conducting those investigations are telling those individuals that the lawyers represent the company. They don't represent the individuals. But what's also happening is those individuals provide information to the company lawyers. The company wants to obtain relief from the prosecutors. They will take that information and give it to the prosecutors. And then the prosecutors will use that information to prosecute those same individuals. And so in that situation, the individuals and the company's interests are not aligned. Not at all. So the leniency program has a lot of advantages. It allows companies also to conduct effective internal investigations, and it does result in the detection of cartel activity and the advancement of companies that really want to put this kind of conduct behind them.
Yeah, but it has become clear that going back to the full spectrum of the negative consequences of being in an antitrust cartel and being caught, there is the criminal offense, the criminal case, there is the fines that can be imposed, and there is also the civil litigation, the treble damages, and the private enforcement. So with the leniency program, the company can get immunity from the criminal side, but evidently that is appetizing for the company, because otherwise they wouldn't do it. But what is the scenario of a company in a big cartel case that goes into leniency, and what will happen later with the civil litigation? What's the scenario that they face?
Okay. Well, let's just for the company, let's go through again what the rewards are. First, the company avoids criminal prosecution. That means there is no, and let's assume we're going to juxtapose this leniency applicant with a company that is convicted. So the company, first of all, avoids a criminal prosecution. So that means, first of all, it doesn't have a felony conviction. These are felonies in the United States, and companies that are convicted have felony convictions. And felony convictions obviously have their own collateral consequences.
So the legal entity can have a felony conviction?
The legal entities are charged criminally, and it's a felony conviction. So the first reward that a company gets is that it's not criminally charged, it's not criminally convicted, it does not have a felony conviction next to its name. Mm-hmm. And of course that can be very important in future dealings with financial partners, banks, regulators, etc. Second advantage is, as you pointed out, that a company that successfully obtains leniency or receives a full pass from any penalties, so there is $0 in fines. Mm-hmm. And as we've talked about, the criminal fines can be very heavy. In the last year, for example, the division collected over $1 billion in criminal sanctions against corporations. The third benefit is all of its officers, directors, and employees receive a pass from prosecution, and so none of its executives are prosecuted. Now, you question, though, began to get into talking about what about the other collateral consequences. And one of the collateral consequences for in antitrust cases in the United States is, as soon as the antitrust division opens up a criminal investigation that becomes public, it's usually a very safe bet that there will be treble damage actions brought in the United States, class action lawsuits, and the leniency applicant is not spared from that. But there is some relief that has been available for leniency applicants in those causes of action. In 2004, there was a law passed again to help induce leniency applications, and this inducement was to de-trebleize. I'm sure you'll find that word in Webster's dictionary. To eliminate treble damage exposure for leniency applicants that cooperate with private plaintiffs.
Well, that's a very important incentive.
Yeah, so instead of, well, there's actually two. So the exposure for leniency applicants is not triple damages, it's only single damages. There's also another benefit. It also eliminated joint and several liability for the leniency applicant.
Which means?
So in the United States, let's talk about let's go back to the cartel member who lost the race for leniency. That cartel member, in addition to all the criminal sanctions that I just described, is vulnerable to having to pay triple damages caused by the cartel activity. But it's not limited to triple damages caused by its own cartel activity or its own sales, or the damages suffered by the victims who brought its product. A cartel defendant is liable for triple damages caused by the entire cartel. That's called joint. You are joint and severally liable. Each defendant is joint and severally liable for the total amount, potentially. Wow. So in this case, what happens is the leniency applicant's exposure is limited to single damages, and elimination of the joint and several. Elimination of joint and several liability, which means actually all the other cartel members in theory, have to pick up his share as well. So it's now, having said that, if you're a leniency applicant, this is no picnic in terms of there are going to be collateral consequences. There are going to, your leniency applicants also end up paying significant damages, and there are collateral issues.
Let me ask you about the reputational damage. Do you think that a company can, at the end of a leniency program, save face, show that they were okay, they were involved in something that is illegal, but they came forward, they reconsidered, or they found out that there was wrongdoing in some part of their executives, and is it seem positive at the end of the day that a company applies?
Well, I think probably the answer to that depends in part on culture, so I imagine there are some situations where leniency applicants, companies that are associated with self-reporting and implicating others, is probably more complicated, and there's a more negative perception than others. I don't think, but I think where there is strong compliance culture exists, and I would say that the United States is an example of that, where there's a strong corporate compliance culture that I don't think it's a stain that it could be in other jurisdictions. But let me just mention another advantage. What is, I mean, there is something that's common everywhere with respect to companies that find themselves involved in government investigations. What do they all share in common? They want to put it behind them. And many companies end up accepting responsibility when there are opportunities to fight. These are well-resourced companies in antitrust investigations. They have resources, they've got lawyers, good lawyers who are ready to fight on their behalf if that's what the company wants to do. But if the company is convinced that there is, they were engaged in wrongdoing and there is evidence of that, they oftentimes will not fight to the last day because they want to put the matter behind them. They want peace. They want to be able to continue on with their business. They don't want the distraction of the investigation. They don't want to have to deal with banks and other financial partners and have to keep saying, well, we're under investigation. What's your exposure? I don't know. It's potentially great. It's up to $100 million. So going back to the leniency program, what an advantage that a leniency applicant has is it's already on the path of putting the matter behind it. It can tell financial partners that its exposure is zero. It is in a position where it can go out and negotiate resolutions with the victims and basically accept a responsibility, negotiate a resolution, and put it behind them way before, in many cases, the other companies who are still struggling to get their arms around the conduct, who are still uncertain in terms of what their exposure is, and will likely be dealing with the ramifications of the civil lawsuits for many more years to come.
Scott, I want to give the members of the SEDEC the opportunity to ask you any questions. If anybody has a question or a comment for Scott.
Thank you so much for being here with us. Let's talk about extraterritorial enforcement of the United States antitrust law, and especially the issue of extradition. Because, correct me if I'm wrong, but several decades ago, when this process started, several countries were reluctant to cooperate with the United States. For example, there were some blockade institutes in the United Kingdom, global legislation in Germany, Canada, Australia showed great resistance to this program. But what has happened since then? Is that changing? Is it now cooperating with the extraditions? For example, we see in the LCD cases, Japanese executives being extradited to the United States, I suppose, to serve terms in jail.
That's an excellent and very astute question. So just to make sure everybody heard it, he talked about back. You really don't have to go that far back. If you go back to the early '90s, at the Antitrust Division, when we first started trying to conduct international investigations, and we would reach out to other jurisdictions around the world asking for assistance, we didn't get it. In fact, we were lucky to even get a return phone call. And that has changed dramatically. So the question was, how has it changed? And the answer is, the change has come because of what has become a consensus around the world of how harmful cartel activity is. An appreciation that strong cartel enforcement is required to protect consumers in jurisdictions around the world. That appreciation didn't exist back in the time that, back as early as the 90s. I'll tell you, one of the things that really did change that was the licensing case, something that Alfonso, you and I were talking about. That was a case in which the Department of Justice and the FBI caught a international cartel in the act, had a cooperating witness, at the time cooperating witness, who helped the FBI videotape conversations involving a product.
Yes, in the movie I didn't see who made you roll.
Yeah, I ended up on the cutting room floor. But what that cartel demonstrated the enormous power of international cartels, because if you saw the movie, it accurately captured the fact that a couple of executives from 5 companies around the world could determine what the price would be for this product down to the penny per pound, effective the very next day. Done. That was the price.
And they met abroad, right?
Well, this cartel met abroad, but it also met in the United States, which after this case became public, people stopped doing. So the Department of Justice prosecuted that case. It was a landmark prosecution. It resulted in a fine that was 7 times higher than any previous fine. It resulted in jail sentences of up to 3 years. It was the first time that a foreign national actually came to the United States, agreed to plead guilty. No jail time, mind you, but agreed to plead guilty and cooperate in our investigation. There was a number of milestones associated with it. But what happened afterwards was that the Department of Justice put together a compilation of highlights from that tape showing how it wasn't just U.S. businesses and consumers and farmers that were being victimized. There were victims all around the world. It was just only the Department of Justice at that point in time that was prosecuting the conduct. So customers, farmers, businesses elsewhere, their rights were not being vindicated. So we put together a tape of those highlights. We showed it at the OECD. We made it available to academics and practitioners and general counsel and companies around the world. You could still contact the Department of Justice to get a copy of this tape. And that was the beginning of what was really an eye-opening process, because many jurisdictions began to see how unambiguously harmful that conduct was. And so even though antitrust was an area where there was a lot of differences in terms of thought, in terms of what conduct should be, what is anti-competitive, what should be criminal, what should not be criminal, this was something that people all began to rally around as harmful conduct. Not necessarily that it should be treated criminally, but that was so unambiguously harmful that it should be sanctioned. And those attitude changes then began to show themselves in terms of assistance requests, in terms of cooperation, in terms of developing. Eventually there was a network of enforcement that began to develop. And you mentioned also in your question where we are today, in which foreign nationals are serving time in U.S. prisons. You referred to executives from Asia in the LCD case serving jail sentences. Those individuals were not extradited, though. Those individuals, but it's actually more remarkable what's happened. Those individuals have voluntarily returned to the United States and then served time in U.S. prisons. So why the heck would anybody voluntarily get on a commercial airline in Japan, fly 5,000-10,000 miles back to the United States, not to go to Disneyland, but to report to a U.S. prison? Well, the reason is, and I'm sure each individual that does that is an intensely personal decision, and it's not the case that every individual does. There are a number of fugitives that have not returned to the United States, but there are now about 75 or 80 or more individuals that have voluntarily done just that from more than a dozen different countries, and it's because they've decided that the alternative is worse. So they've decided that they want to put the matter behind them. They understand that the world is changing. They understand that even if they're in a jurisdiction that doesn't extradite today, that can change. They understand that jurisdictions around the world are increasingly criminalizing conduct. They understand the Department of Justice will likely put those individuals on Interpol Red Notice watches, and they will try to track their movements, and if they move into a country where extradition is possible, they will try to have them detained and brought back to the United States. It's high stakes. And so that has caused a lot of individuals to decide that they did violate U.S. antitrust laws. The Department of Justice has the evidence to prove that, and they choose not to live the life of an international fugitive, but rather to accept responsibility. But obviously it's quite a remarkable change in the enforcement landscape.
Yes, Javier.
Thank you. What would you think about the possible extraditions from Colombians to the U.S. for antitrust violations?
Well, we haven't seen that yet.
Probably.
Well, I can't answer. I'm not familiar enough with the U.S.-Colombian extradition statute, so I don't know if it requires dual criminality. If it required dual criminality and the conduct involved bid rigging, then extradition could be possible both ways. And I would say that if the U.S. Department of Justice uncovered, let's just say, an international cartel in which a Colombian company was involved in bid rigging in the United States, then I would certainly expect that the U.S. Department of Justice would probably seek to hold individuals accountable involved in the conduct. And if one of those individuals was a Colombian national, they probably would seek to utilize the extradition statute. Of course, this is all hypothetical, but it has not differentiated between nationalities. That the goal of the view of the Department of Justice is that one of the greatest threats to U.S. business and consumers today lies in international cartel activity. That it needs to be vigilant in protecting consumers from cartel activity aimed at our economy from wherever it comes from. And so if that's in South America or Asia or Europe or wherever it is, it will try to protect consumers, and it will try to hold individuals accountable so that it deters the activity and so that there's no perception that there's safe harbors around the world where you can't target the U.S. economy.
Yes, thank you. Now, the European academies are debating about the difference between administrative enforcement control and trial enforcement, criminal enforcement. In the United States, it seems to me that we have these two types of enforcement, one from the FTC and one from the Federal Trade Commission. What can you tell us about the difference of procedures?
Well, we actually, in the area that we've been talking about, you don't have dual jurisdiction. So you only have the criminal prosecution. So you're quite right that in the United States, we have two competition authorities. you have the United States Department of Justice Antitrust Division, and then you also have the United States Fair Trade Commission. And they have shared sovereignty over some competition offenses, and they have, for example, they both would have shared authority to review potentially unilateral conduct, anti-competitive conduct. There's shared authority to review mergers and acquisitions. Only one authority will actually do the investigation, but there is shared jurisdiction. When it comes to the criminal prosecution of the antitrust laws, jurisdiction for that enforcement falls solely within the Department of Justice.
Okay.
Thank you. Here in Colombia, we only have one criminal anti-competitive behavior, which is the rigging. It's a criminal offense. It's a felony. I think it's 6 to 12 years. It means prison time. But it's the only antitrust violation which is criminal. What would be your advice regarding to why that's scope, and that in the sense that anti-competitive behavior can be, or criminal cartel activity in general would be a criminal offense. But what would be your advice?
To be or not to be?
No, well, I mean, just as a first observation, I don't know. Bid rigging behavior is just one type of activity that we would refer to as hardcore cartel activity. So I don't necessarily agree that bid rigging. It's hard for me to see bid rigging as criminal, but price fixing or market allocation agreements as being not criminal, because the effects you can. I mean, we've seen plenty of price fixing conduct that's more harmful than some of the bid rigging conduct that we've seen. But I do, as I said, this jurisdiction is not alone in singling out bid rigging activity, and I think, as you said, it's because of this notion of corruption, and that it can be the case that you have bid rigging conduct that is committed in conjunction with other public corruption, and so for that reason, sometimes bid rigging will be singled out for criminal prosecution.
Which is the case, the Colombian case.
Yes. My advice is, first of all, maybe to take a look at what's happened in Brazil, because I think it is a success story. It is, but it is extremely difficult to make the transition, and so in some ways it does help to have a maturation of the competition authority before making that move. It's very difficult because there has to be a partnership, a real partnership that develops between the competition authority and the prosecuting authority. In many jurisdictions that have criminal sanctions aren't using them, and the competition authority is reluctant to push for the use of criminal sanctions because there are serious concerns with respect to whether the prosecuting authority will prioritize criminal sanctions or prioritize cartel offenses, will dedicate sufficient resources to criminal investigations and prosecutions, will develop the necessary expertise to have a successful cartel enforcement program. So there's a concern that if you take the enforcement of cartel activity away from the competition authority and give it to the prosecuting authority, by criminalizing all the cartel activity, that it will actually result in a reduction in cartel enforcement, because the prosecutors are busy, they've got other priorities, they're working on all these other more important cases, and they'll ignore the cartel investigations and prosecutions. And so you can make the argument that criminalizing the conduct will actually result in a drop in cartel enforcement. I say look to Brazil because that's not what happened in Brazil. But the reason why it hasn't happened in Brazil is because the competition authority there works so darn hard to recruit and educate the federal police and the federal prosecutors, and to bring them into a real partnership, first with SDE and CAJE, and now with CAJE itself. I've been down there, I've seen it firsthand. I've seen them bring in prosecutors and federal police from around the country. They've created forensic labs for the federal police to assist in their investigations. They have developed a partnership with respect to the application of the policy program. And they have, so now they are benefiting from the fact that there is a perception of, so that now they have this cornerstone that we talked about. They have criminal sanctions. It creates a significant inducement to self-reporting in Brazil. They are sort of developed a reputation as being a must-see jurisdiction. So if you're an international company, you're engaged in cartel activity, and you decide to report in the United States, and you're going to go into the European Union because they're imposing fines of $1 billion, and maybe you're going to go into Canada as well because they've got criminal sanctions and they're prepared to use them. And now you're also looking down at Brazil and you're saying, we're going to have to get our butts down there too, because they've got criminal sanctions and their enforcement program is not to be ignored. Don't mess with Brazil. Many of you probably saw a sanction that was imposed by a court about a month or two down there, where an individual was sentenced to more than 10 years, and the individual was sentenced to a fine of about $140 million, plus the jail sentence. And that was the court, that wasn't the competition authority. So Brazil and CAJE has gotten the attention of multinational companies around the world. The last thing I want to mention in terms of this partnership is the leniency program has become so critically important to competition authorities as an investigative tool. So there shouldn't be any confusion about why authorities give leniency. It's not because we are handing out salvation to wrongdoers. It's because it's perceived as the most effective investigative tool ever created for competition enforcement. And having criminal sanctions can become the greatest incentive to take advantage of the leniency program. Criminal sanctions can be the greatest deterrent to committing offenses, and if they are committed, it can be the greatest incentive to encourage people to self-report and cooperate and accept responsibility. Except if you have a separate prosecuting authority that does not respect the grant of leniency. If you have a situation where a company believes that if they come in and self-report, they are absolutely certain that they will get a pass from prosecution from the competition authority, but they have no certainty whatsoever with respect to what the prosecuting authority will be, and in fact they think if they come in and self-report, they are opening themselves up to criminal prosecution, then now we've just turned this thing on its head. Instead of having the greatest incentive to self-reporting, we've now created the greatest disincentive to self-reporting. And so this is an issue that many jurisdictions struggle with. How do we get, if we have a criminal law, we've got these prosecutors, and they act independently, and there's never been a relationship that exists between the prosecuting authority and the competition authority, how do we bring them in? Because I can tell you the first time the prosecuting authority, I don't care where we are in the world, hears about this leniency program, they're going to be like, what are you talking about? We don't give leniency. We certainly don't give automatic leniency. And they're going to want to treat this like any other offense, which is not what's happening in the antitrust area. It's not what happens in the Department of Justice. As successful as we are with our leniency program, I just have to walk down the hall. They're not, when I was there, they're not using this kind of leniency program to investigate other offenses. So it is a very unique tool, even in the United States. So this is where the rubber hits the road in terms of the criminal prosecutions. It's developing those kind of relationships. And again, I'll just point back to Brazil. If you're the SIC, or frankly, you don't have to be a Latin American authority, to look at them as a very good example of how to bring the prosecuting authority in and make a stronger partnership.
Scott, thank you very
I
much.
just want to have one last question.
We will give leniency for one last question.
Just following Alfonso's question before on the reputational impact of leniency, I would like to know if, according to the experience in the States, if there's a life after leniency for companies and businessmen, or not necessarily.
Absolutely. I mean, look, when we talked about the consequences, it's not that you come in and get leniency in your company and you walk away. You're going to have financial exposure, and you're going to be it's still going to be living with you for a while. But you asked about it, but I think it's easier to put the matter behind them that way, and certainly for individuals. If we're talking about individuals, these individuals walk away without a criminal prosecution, without a felony prosecution. Their identity is more easily to protect, and as compared to what we talked about, the average case in the United States.
But will they be a CEO again?
That's the question, yeah.
Well,
or a board member.
Or a board member,
yeah.
or a respected member of the business community.
In the United States, they probably will not keep their jobs where they were, because most companies in the United States, they're involved in this type of conduct in-house. That's a generalization, but when I look around the United States compared to the rest of the world, there is part of the corporate governance usually means replacing individuals that are involved in conduct. But it's much easier to go get another job if you don't have a felony conviction next to your name. It's much easier to get another job if you're not applying for it while you're serving time in a U.S. prison as your return address on where you can be reached. So that is, yes, there is life after leniency for sure for individuals. And the path going forward, both for individuals and companies, is a lot smoother.
Thank you very much. Scott, we could be here for the full day. As you can imagine, we have a lot of questions, but
excellent questions.
We appreciate very much that you are here at the SEDEC this morning, and it's a real honor to have you here. You have here very important practitioners and academic persons who have a great interest in all of your experience.
Oh, thank you.
Thank you very much
for this morning. It's been my pleasure. Thank you for
Okay.
your excellent questions.
Thank you.
Thank you very much.